another issue because, as you know, in Parliament on Tuesday, a number of things happened, including an attempt by the opposition to table a motion of no confidence. And I believe I heard the leader of the opposition mentioning the power of a no confidence motion. And he is absolutely right that if a no confidence motion succeeds, then it leads to the dissolution of Parliament. So, part of the Constitution says in the exercise of his powers under this section, the Governor-General shall act in accordance with the advice of the Prime Minister, provided that if the House of Representatives by a resolution, which has received the affirmative vote of a majority of all members thereof, has resolved that it has no confidence in the government shall, by proclamation published in the Gazette, dissolve Parliament. So a vote of no confidence can lead to dissolution of Parliament by the Governor-General, because the no confidence motion means the Prime Minister does not have the authority he once had. So the Governor-General steps in and acts. But before you can get to the Governor-General doing that, you need to receive the affirmative vote a majority of all the members. It was never going to be possible within the context of the makeup of the House at the moment. Never going to be possible, especially when we've had a social media compilation with most, if not all, government MPs signaling their continued support for the Prime Minister. So what came up in Parliament wasn't the tabling of a motion that one hoped could succeed, because it couldn't. It was something to put in the annals of history. The moment that the leader of the opposition believes is advantage to the opposition. And politically, I completely understand that. When you are up on a juggler for opposition and government seems to be against the wall, you have to do everything that you can, especially so close to an election, to keep the political heat on the government. And they all do it. They all do it. So I can't fault the leader for wanting to do that. Based on what I've heard, it doesn't appear that he'd given sufficient notice. And even if he gave sufficient notice, perhaps a decision would have been taken not to have allowed it. And truthfully, as I said, the vote would never succeed because of the sheer numbers. So what you would have are opposition members perhaps being given the chance to say their piece, to debate within the context of the privilege that Parliament allows for all sort of things to be said on the floor of Parliament, and government having the chance to respond, but it probably would be a grand waste of parliamentary time because it can't lead to a dissolution of Parliament by the Governor-General. Yeah? And so the issue was raised by Pernell Charles Jr. about whether it's appropriate for even the motion to be tabled in Parliament because of the filing of the application in the Supreme Court of the application for judicial review, leave for judicial review by the Prime Minister and the other companies. And I've heard the questions being asked whether it was sub judice. I understand that a colleague of mine who spoke on all angles, he held the view that the matter really couldn't properly be considered sub judice because a date had not yet been set by the court, and the matter was therefore not yet under judicial consideration. But from my little understanding of applications for leave for judicial review, when you file your notice, the rules say that the application for leave must be considered forthwith by a judge of the court. And in fact, your application can be heard. Well, the leave can be granted without the judge even hearing from you. The judge can consider the application on paper. So to my mind, the mere fact that you file and the court is duty bound by the rules to consider the application forthwith, and because permission can be granted without you even knowing because you don't have to appear, it seems to me that the moment the matter is filed, it can almost be considered a couple of hours after that to be under judicial consideration. It may very well be that the judge directs a date for hearing the application, or the judge can also direct that specific individuals be served, or even that the Attorney General be served. But in the absence of all of that, the application itself can operate almost like what they call an ex parte application. The judge can look at what you have on paper and decide, is there an arguable matter here before me such that I can form the view that there is some prospect for sending this matter for a full review. So to that extent, I think the date of filing of application for leave for judicial review, because of how it operates, it really can be considered that it is now out of the scope for discussions. And that's what they call sub judice. But I happen to also think that, especially because it's cards on the table, a lot of things that used to happen before, where people turn up on the morning of the hearing of a matter and pull out some sort of paper that you'd never seen before, those times are long gone. In fact, I never ever had those times in my practice of law, which is now 13 or so years. Because of that, it is highly unlikely that the bounds of this sub judice rule as we know it is so easy to breach these rules. So I find that a lot of people raise this as a defense when they sort of want to stifle something that is politically disadvantageous to them, or to stifle the freedom of expression that now obtains in sort of wider expanse in this time. And I think, especially where the Parliament is of the composition that it is, and with all of the matters now coming to public attention for debate, I believe that where speakers are authorized under the standing orders to allow for discretion to prevail for the tabling of motions in Parliament and for debate on some motions, even if the motions are unfavorable to a member of the government side, I believe that speakers should try and exercise their discretion to allow the debate of those motions. Because I keep saying on this program, democracies die in the dark. It cannot be that people are feeling that you don't want this particular issue to be heard because it doesn't look good politically. And on top of that, you have to do the political calculation too. As I said, it is not likely at any point in time with this particular parliamentary makeup that a vote of no confidence against the Prime Minister will succeed. And I do not know what other arguments can be made separately from all the others that have been made on the political campaign over the last however long. Yeah, so parliamentarians, speakers, deputy speakers, you need to consider your overwhelming majority and know that you must try and foster debate as far as is possible, even if appearingly politically unpalatable for your side. Yeah, I can't tell the opposition not to do, because every single opposition party, you have to go for the jugular. Right? But this application, I come back to it. I look forward to the court hearing it quickly And as I said to Derek yesterday morning, based on my reading and my discomfort with a lot of things in the report, I'd be surprised if other people don't make the application for judicial review or some other sort of action. And we need clarity in the law. The directors too need clarity on how they're supposed to operate, especially because the law is so young, and it really can't hurt in turning to the court, which is the only authorized entity to give the sort of clarity and declaratory relief that people are entitled to seek by way of leave for judicial review. I won't even touch the other matter now concerning the PNP's candidate for Portland Eastern. We'll wait until some other time. Those are my thoughts for the moment.